Hello. Today I'm at the Old Sly Fox, which is on Hurst Street in Birmingham, opposite the Hippodrome Theatre, which is owned by Keith Williams. I first met Keith around 25 years ago. He used to own a place called Studebaker's in Birmingham back then with his business partner Mark Jones. And when I was at Whitbread, we were the East Midlands team, and we used to have our Christmas parties in Birmingham, and frequently ended up in Studebaker's. So I've known Keith a quarter of a century, and I'm here today to discuss prosecutions under the Licensing Act. I've dealt with quite a few of those in recent years, although I must hasten to add none involving Keith Williams or Mark Jones for that matter. There are a number of offences under the Licensing Act which are rarely, if ever, exercised, certainly in my experience. For example, selling alcohol to somebody who is drunk is an offence, but I've never known anyone be prosecuted. I've known a few fixed penalty notices, but certainly never known anyone be prosecuted for that offence in my time at the bar. There are essentially three principal offences which are most frequently prosecuted. The first of those is sale of alcohol to a minor or to a child, which carries a maximum sentence of a fine. And it's worth noting that it isn't just the person who made the sale who can be liable to prosecution. It can also be the licence holder themselves if they've not exercised appropriate levels of due diligence to avoid the offence being committed. Second of these offences is under section 144 of the Licensing Act, that is keeping smuggled goods on licensed premises, alcohol and tobacco most frequently, and the maximum sentence for that offence is again a fine, although it's worthwhile noting that frequently prosecuting authorities use alternative acts of parliament, such as legislation in association with customs and excise or trademarks to prosecute, especially in relation to illicit cigarettes. The third offence, which is most commonly prosecuted under the Licensing Act, and in my experience the one that's most frequently prosecuted of all, is under section 136, namely where someone has carried on or attempted to carry on a licensable activity other than in accordance with an authorisation, which essentially means, or certainly most frequently means, where somebody's breached a condition on a licence, or they've operated outside their authorised hours, although it can also apply where someone, for example, sells alcohol where they don't have any licence at all. Anyone prosecuted under section 136 of the Licensing Act is afforded a defence under section 139 of due diligence. That is to say that they've done everything they reasonably can to avoid the offence being committed, and certainly I've had some considerable success in running that defence at court on behalf of defendants that I've represented. It's also worthwhile noting that it's an offence under section 137 of the Licensing Act to have alcohol on display for sale without the appropriate authorisation, and that frequently applies where a premises licence has been suspended, and for the duration of that suspension it's important that the licence holder either covers up or removes from the licensable area any alcoholic products. Prosecutors have a period of 12 months from the date of the commission of the alleged offence to bring a prosecution under the Licensing Act, and furthermore they also have the power to prosecute individuals who are directors of companies who are alleged to have committed offences under the Act.